The Ohio Supreme Court conducted its first oral arguments of the year in January 2025, hearing 8 cases dealing with a variety of legal issues. The cases included 2 challenges to the Ohio Power Siting Board's approval of solar power facilities that are scheduled to be built in Licking and Hancock counties. South Branch Solar is proposing a solar farm in Hancock County near the village of Arcadia. The project has drawn opposition from some local residents, including Travis Bond. He represented himself before the Supreme Court. Central to his argument was that the siting board allowed South Branch Solar to highlight only its positive impacts without considering the negatives. South Branch disagreed.
So you only give us positives?
No, Your Honor. The statute doesn't discuss negative economic impacts. In fact, that's a term that
doesn't discuss positive only. It just says, what are the economic impacts?
That is correct, Your Honor. It requires the applicant and the board to investigate the economic impacts, and that's exactly what it has done.
They talk about all the power that's going to be created by this, but what they fail to mention is all the food that is getting lost. So it's hard for me to compute that when, you say it's all good, but they keep leaving out all the bad, and my little town's the one that's right in the middle of the bad.
The court also considered a dispute in Harrison County regarding oil and gas drilling rights. The nonprofit Faith Ranch and Farms Fund argued that land it purchased in the 1970s was free and clear of any previous claims by others to drill for oil and gas. But the Fay Mayer estate claimed that in a 1953 deed, their family reserved the rights to drill. The lease used the terms right to mine and remove such coal or other minerals of any vein underneath the land. The Supreme Court justices challenged both sides to explain if the deed intended minerals to include oil and gas. The justices also wanted to know if the use of the word vein meant the family only had rights to coal and other hard minerals, but not oil and gas.
Harrison County, Ohio, and I'm going to convey you the land, and there is a well down the road that is going to make me millions of dollars because I own the oil and gas. I'm not going to only reserve the minerals. I'm going to make sure that you know that I'm reserving the oil and gas.
We know the common meaning of vein, as you indicated, from the dictionary at the time.
Well, there's lots of dictionaries at the time, right?
Sure.
And
yes.
Lots of the dictionary definitions at the time would exclude something that's not solid.
News sources from New York Times, Wall Street Journal, Houston Chronicle, Chicago Tribune, Associated Press, USA Today. I mean, these are just coming to me from memory, but all talking about striking veins of oil, striking veins of gas, discovering new veins of oil, discovering new veins of gas.
In a third case, the justices considered whether Ohio Attorney General Dave Yost could be forced to answer questions under oath about any records regarding his interactions with the Republican Attorneys General Association and a related organization. The Attorney General's office argued a deposition is unjustified and could lead to continuous efforts to distract and take valuable time away from high-ranking government officials. On the other hand, the Center for Media and Democracy argued the public has a right to know whether the Attorney General's interactions with national organizations plays a role in public policymaking and in Yost's actions as a public official. The parties painted starkly contrasting views of the implications of allowing a court to order the Attorney General to sit for the deposition and produce records from his personal devices.
Even if a 2-hour deposition in one particular case wouldn't be disruptive, you have to ask what the children's book did. What if everybody did? Essentially, this is a question of if the precedent is set for a deposition of the Attorney General in this case, it will be open season for lawfare and the weaponization of the Public Records Act for witch hunts by every gadfly.
In the wrong hands, a decision of this court denying discovery under these circumstances would allow a public official to unilaterally, unreviewably determine that entire categories of what should be public records are not public.
Chief Justice Sharon L. Kennedy announced the court will take the arguments under advisement and inform the parties of its decisions. The court meets for oral arguments at the Moyer Judicial Center in Columbus. Each session begins at 9 a.m. You can also see them live online at supremecourt.ohio.gov.